Picture this. You're standing in your own driveway, watching as 3 HOA board members march toward your front door with official-looking documents, their faces twisted with smug satisfaction. They think they've finally found the perfect weapon to force you out of the neighborhood you've called home for over a decade. But what they don't know is that you've been quietly preparing for this moment for months, armed with legal knowledge that's about to turn their world completely upside down. This is exactly what happened to Sarah Mitchell, a 34-year-old marketing professional who thought she'd found her dream home in the prestigious Willowbrook Estates. What started as petty complaints about her garden gnomes would escalate into a full-scale war that would expose the dark underbelly of HOA corruption, reveal shocking abuse of power, and ultimately lead to the most satisfying legal comeback you've ever heard. Where are you watching from? Please feel free to leave a comment below, as you are about to witness one of the most epic David versus Goliath battles in HOA history, where knowledge of property rights became the ultimate weapon against bullying board members who thought they were untouchable. By the end of this story, you'll understand exactly how Sarah turned the tables on her oppressive HOA, and why every homeowner needs to know these crucial rights that could save their home and their sanity. Sarah Mitchell had always been the type of person who followed rules. As a successful marketing executive, she understood the importance of structure and order. So when she purchased her beautiful colonial-style home in Willowbrook Estates in 2019, she actually appreciated the idea of living in a well-maintained community with clear guidelines. Willowbrook Estates was everything Sarah had dreamed of: tree-lined streets, manicured lawns, and homes that maintained their value through what seemed like reasonable community standards. The HOA fees were steep at $200 per month, but Sarah figured it was worth it for the amenities: a community pool. The HOA was governed by a 5-member board, but 3 individuals held all the real power. There was Margaret Henley, a 67-year-old retired real estate agent, who had served as HOA president for 8 consecutive years. Margaret ruled the community with an iron fist, believing that her decades of real estate experience gave her the authority to make unilateral decisions about everything from paint colors to landscaping choices. Then there was Robert Chen, the vice president and Margaret's right-hand man. Robert was a 52-year-old attorney who had moved to the neighborhood specifically to join the HOA board. He enjoyed wielding legal threats like weapons and had a particular talent for finding obscure clauses in the community's governing documents that he could use to intimidate residents. The third member of this power trio was Linda Vasquez, the treasurer and self-appointed community standards enforcer. Linda spent her retirement driving through the neighborhood with a digital camera, documenting every perceived violation and building files on residents she deemed problematic. For the first year, Sarah flew completely under their radar. She kept her lawn pristine, painted her shutters the approved forest green, and even volunteered for the annual community garage sale. She thought she had found the perfect balance between homeownership freedom and community cooperation. But everything changed in the spring of 2020, during the height of the pandemic lockdowns. Like millions of Americans stuck at home, Sarah decided to take up gardening as a therapeutic hobby. She started small, a few tomato plants in her backyard, some herbs by her kitchen window. But as weeks turned into months, her green thumb began to flourish. She expanded her garden, adding colorful flowers, decorative planters, and yes, a small collection of whimsical garden gnomes that brought her joy during those dark, isolated months. The gnomes weren't large or offensive, just 5 small ceramic figures nestled among her flowers, each no more than 8 inches tall. There was a gnome with a fishing pole by her small garden pond, one reading a book under her rose bush, and 3 others scattered throughout her flower beds. To Sarah, they represented creativity, joy, and a touch of personality in an otherwise sterile neighborhood. But to the HOA power trio, those innocent garden gnomes represented something far more sinister, a direct challenge to their authority. The trouble began with a single photograph. Linda Vasquez had been conducting one of her regular violation patrols when she spotted the gnomes through Sarah's fence. Instead of simply knocking on the door for a friendly conversation, Linda immediately snapped photos and rushed back to Margaret's house to report what she dramatically called a clear violation of community standards. Now here's where the story gets interesting, and trust me, you're going to want to stay tuned, because what happens next reveals just how far some HOA board members will go to maintain their grip on power. Margaret, Robert, and Linda spent an entire evening poring over the community's governing documents, searching for any clause they could use to force Sarah to remove her garden gnomes. The problem was, the documents didn't specifically prohibit garden decorations. In fact, the landscaping guidelines were surprisingly vague, stating only that modifications should maintain the aesthetic harmony of the community. But Robert, with his legal background, found what he believed was their smoking gun buried in Section 4.7 of the Covenants. No resident shall make exterior modifications or additions that materially alter the appearance of their property without prior written approval from the Architectural Review Committee. This clause had been designed for major changes like room additions, fence installations, or significant landscaping projects. But Robert convinced his fellow board members that garden gnomes constituted exterior modifications that required approval that Sarah had never requested. Armed with this interpretation, Margaret drafted the first letter that would arrive in Sarah's mailbox on a sunny Tuesday morning in June 2020. The letter was printed on official HOA letterhead and carried the authoritative tone of a legal document. It read, "Dear Ms. Mitchell, it has come to our attention that you have installed decorative garden elements without obtaining proper approval from the Architectural Review Committee. You have 30 days to remove these items or submit them for retroactive approval, subject to a $50 processing fee. Failure to comply will result in daily fines of $25 until the violation is corrected." Sarah's first reaction was confusion. Garden gnomes needed approval? She had read through the community guidelines before purchasing her home and didn't remember any such requirement. So she did what any reasonable person would do. She called Margaret Henley directly to discuss the matter. The conversation did not go as Sarah expected. Margaret's tone was cold and dismissive from the moment she answered the phone. She informed Sarah that the board's interpretation of the covenants was final and non-negotiable. When Sarah pointed out that many other homes in the community had garden decorations, wind chimes, and decorative elements, Margaret's response was chilling. "We address violations as they come to our attention. Your non-compliance has been noted and documented." But here's where Sarah made her first crucial mistake, and why you need to pay close attention to what happens next, because this could happen to anyone living under HOA rules. Instead of immediately researching her rights or consulting with a legal expert, Sarah decided to comply. She genuinely believed that cooperation would resolve the conflict. She removed her beloved garden gnomes, storing them sadly in her garage, and paid the $50 retroactive approval fee, even though she felt it was unfair. Sarah thought this would be the end of the matter. She was wrong. Removing the gnomes didn't satisfy the board. It emboldened them. Margaret, Robert, and Linda had tasted victory, and they decided Sarah needed to be taught a more comprehensive lesson about respecting their authority. 2 weeks after Sarah removed her garden gnomes, another letter arrived. This time, the violation was even more absurd. Her mailbox was the wrong shade of black. According to the board, the approved color was classic black, but Sarah's mailbox was apparently charcoal black, a distinction invisible to the naked eye, but grounds for another $25 daily fine. Sarah was stunned. She had purchased her home with this exact mailbox, which had been there for 3 years without any complaints. She took photographs of her mailbox next to her neighbor's, documenting that they were virtually identical. But when she presented this evidence to the board, Robert Chen's response revealed the true nature of their campaign against her. "Previous violations don't justify current ones," he wrote in an email that Sarah would later use as crucial evidence. The board has the discretion to enforce standards as we see fit, when we see fit. Your compliance history will be taken into consideration for all future decisions. The message was clear. Submit completely, or face escalating consequences. But Sarah was beginning to understand that compliance wouldn't save her. Over the next 3 months, the violations kept coming with increasing frequency and decreasing logic. Her garden hose was improperly stored. It was neatly coiled behind a bush. Her garbage cans were visible from the street. They were in the exact location prescribed by the waste management company. Her car was parked incorrectly in her own driveway. It was 6 inches farther from the garage door than the board preferred. Each violation came with fines, and the fines were adding up quickly. By September 2020, Sarah had accumulated over $800 in penalties for infractions that she couldn't even understand, let alone correct to the board's satisfaction. And here's what makes this story even more infuriating. Sarah discovered that she was not the only target. During a chance conversation with her neighbor, Tom Rodriguez, Sarah learned that the board had been systematically targeting homeowners they perceived as problematic. Tom revealed that he had been fighting his own battle over a decorative bird bath that the board suddenly deemed non-compliant after sitting in his front yard for 5 years. Another neighbor, elderly Mrs. Patterson, was being fined for having the wrong color mulch that she had purchased from the same garden center recommended by the board the previous year. The pattern was becoming clear. Margaret, Robert, and Linda were using selective enforcement to harass residents who didn't show proper deference to their authority. They were creating an atmosphere of fear and confusion where homeowners never knew which arbitrary rule would be used against them next. But Sarah was about to discover that the board had much bigger plans for dealing with non-compliant residents like her. In October 2020, she received a letter that made her blood run cold. The board was implementing a new policy requiring all homeowners with multiple violations to attend mandatory compliance meetings. Sarah's file, they claimed, showed a pattern of disregard for community standards that required immediate intervention. Now, I want you to remember this moment, because what Sarah discovered at that compliance meeting would change everything and set the stage for the most dramatic showdown in Willowbrook Estates history. The meeting was held in Margaret's living room with all 3 board members present, and Sarah sitting alone on the opposite side of a coffee table laden with thick folders, her violation file, which had somehow grown to over 40 pages in just 4 months. Robert Chen took the lead, speaking in the practiced tones of someone accustomed to intimidating people with legal jargon. He informed Sarah that her continued non-compliance had reached a level that threatened the harmony and property values of the entire community. The board had voted to place her on probationary status, which meant any future violation, no matter how minor, would trigger immediate legal action. But the real bombshell came when Linda Vasquez opened another folder and spread out a series of photographs taken from various angles around Sarah's property. These weren't casual snapshots. They were professional quality images that must have taken hours to capture. Photos of her car's license plate. Photos of her living room window from across the street. Photos of her garbage cans from multiple angles on different days. Margaret explained that they were implementing enhanced monitoring for probationary residents. This would include weekly property inspections, documentation of all activities, and a requirement that Sarah notify the board in writing before making any exterior changes, no matter how minor. The message was unmistakable. We are watching you. We can make your life miserable. Submit completely or face the consequences. But instead of cowering, something clicked inside Sarah's mind. The level of harassment, the obvious selective enforcement, the invasion of privacy. This wasn't about community standards. This was about power, control, and intimidation. And Sarah Mitchell, the rule-following marketing executive, was about to become someone these board members never expected to encounter. a homeowner who understood her rights and wasn't afraid to use them. That night, Sarah made a decision that would change everything. Instead of continuing to react to each violation as it came, she was going to get ahead of the situation by learning exactly what rights she had as a homeowner and what limitations actually governed the board's power. What Sarah discovered during her research would shock you, and it might save your own home someday if you ever find yourself in a similar situation. First, she obtained complete copies of all governing documents for Willowbrook Estates, the original Declaration of Covenants, Conditions, and Restrictions, CC&Rs, the HOA bylaws, and all amendments that had been passed over the years. What she found was a document full of contradictions, outdated clauses, and provisions that had been selectively enforced for years. But more importantly, Sarah discovered that the board had been operating outside their legal authority in multiple ways. The CC&Rs clearly stated that fines could only be imposed after a formal hearing process, which Sarah had never been offered. The documents also specified that violation notices must include specific citation of the exact covenant being violated and provide a reasonable timeline for correction, neither of which had occurred in Sarah's case. Even more damaging, Sarah found that the board's enhanced monitoring policy violated several state laws regarding privacy and harassment. Taking photographs of someone's private property without consent, especially from angles that captured the interior of their home, crossed the line from HOA enforcement into potential stalking behavior. Armed with this knowledge, Sarah made her next crucial move. She hired Patricia Wong, an attorney who specialized in homeowner association law. Patricia's initial assessment was devastating for the board. They had violated so many proper procedures that virtually every fine and violation notice Sarah had received was legally invalid. But Patricia advised Sarah to do something unexpected. Instead of immediately demanding the withdrawal of all violations, she suggested they give the board one final chance to back down gracefully by following the proper legal procedures they had ignored. In November 2020, Patricia sent a formal letter to the board requesting a proper hearing regarding all violations, as required by the community's governing documents. The letter was professional, legally precise, and gave the board a clear path to resolve the situation without admitting wrongdoing. Margaret's response revealed just how deep the board's arrogance ran. Instead of scheduling the required hearing, Margaret sent back a dismissive letter stating that the board had already thoroughly reviewed Sarah's case and that no further discussion was necessary. She added that Sarah's attempts to circumvent established procedures by hiring an attorney would be noted in her file. This response was exactly what Patricia had hoped for, clear documentation that the board was willfully ignoring their own governing documents and legal requirements. But the board wasn't finished. In December 2020, they escalated their campaign in a way that would prove to be their fatal mistake. Robert Chen sent Sarah a letter claiming that her continued pattern of violations and non-compliance had reached a level that constituted a material breach of the covenants. The letter stated that unless Sarah brought her property into full compliance within 30 days, the board would initiate legal proceedings to place a lien on her home and potentially begin foreclosure proceedings. This was the nuclear option, the threat that many homeowners fear most. The idea that an HOA could actually take your home over disputed violations is terrifying, and the board was counting on that fear to force Sarah into complete submission. But they had just made a crucial error that would expose them to devastating legal consequences. Patricia immediately recognized that the board's foreclosure threat was not just inappropriate, it was potentially fraudulent. Under state law, HOA liens and foreclosure actions require extensive documentation of properly noticed violations, formal hearings, and due process protections. None of these requirements had been met in Sarah's case. More importantly, the board's own governing documents required a vote of the full 5-member board to initiate any legal action. Patricia's investigation revealed that Margaret, Robert, and Linda had been making these decisions unilaterally, without input from the other two board members who weren't even aware of the escalating situation with Sarah. This discovery opened an entirely new avenue of attack. The three board members weren't just violating Sarah's rights. They were violating the rights of their own community by exceeding their authority. But Sarah and Patricia decided to take an even more aggressive approach. Rather than simply defending against the board's actions, they were going to go on the offensive. In January 2021, Patricia filed a comprehensive lawsuit against the HOA, naming Margaret, Robert, and Linda individually for their roles in what the court documents described as systematic harassment, violation of due process rights, and abuse of fiduciary duty. The lawsuit didn't just seek monetary damages. It demanded a complete audit of the board's activities, the invalidation of all improperly imposed fines, and the removal of all three defendants from their positions. But the real bombshell in the lawsuit was the discovery evidence that Patricia had uncovered. During the legal discovery process, Sarah's attorney was able to subpoena the board's email communications, meeting minutes, and financial records. What they found was a paper trail that documented a deliberate strategy to target and harass homeowners who didn't show appropriate deference to the board as authority. The evidence included email exchanges between Margaret and Linda discussing problem residents who needed to be taught lessons. There were communications with Robert where he outlined strategies for using creative interpretation of the covenants to justify violations. Most damning of all, there were records showing that the board had spent over $12,000 of community funds on legal consultations specifically focused on enhancing enforcement capabilities against residents they didn't like. But the smoking gun came in an email from Margaret to Linda dated 2 weeks before Sarah received her first violation notice. The email read, "The Mitchell woman thinks her cute little gnomes make her special. Let's see how special she feels when she's facing daily fines. Robert found some clauses we can use. Time to remind these homeowners who really runs this community." This single email proved malicious intent, selective enforcement, and abuse of power. It was exactly the kind of evidence that could not only win Sarah's case, but expose the board to serious legal and financial consequences. When news of the lawsuit spread through the community, something unexpected happened. Other homeowners who had been silently enduring their own harassment campaigns began coming forward with their stories. Tom Rodriguez joined the lawsuit, bringing his own documentation of arbitrary violations and improper fines. Mrs. Patterson, the elderly woman with the wrong mulch, provided evidence that the board had threatened to place a lien on her home over $200 in disputed fines. 3 other families came forward with similar tales of selective enforcement and harassment. What had started as Sarah's individual battle against garden gnome violations had exposed a pattern of systemic abuse that affected the entire community. Margaret, Robert, and Linda suddenly found themselves facing not just one lawsuit, but multiple legal actions, a potential criminal investigation for misuse of community funds, and a community revolt that threatened to destroy their carefully constructed power structure. The board's attorney advised them to settle quickly and quietly, but their arrogance wouldn't allow them to admit defeat. They decided to fight back with the nuclear option they had been threatening all along. They actually attempted to foreclose on Sarah's home. This decision would prove to be the most catastrophic mistake of their lives. The foreclosure attempt was so legally flawed that it backfired spectacularly, turning what might have been a quiet settlement into a public relations disaster that would be covered by local news stations and become a cautionary tale for HOA boards across the state. When Margaret, Robert, and Linda filed foreclosure papers claiming Sarah owed over $2,000 in fines and fees, they made several critical errors that demonstrated either stunning incompetence or willful fraud. The foreclosure documents cited violations that had never been properly noticed, included fines that exceeded the amounts allowed by the governing documents, and claimed legal procedures had been followed that were never actually completed. Patricia Wong's response was swift and devastating. She immediately filed an emergency motion to stop the foreclosure, accompanied by a comprehensive brief that laid out every procedural violation, every abuse of power, and every instance of selective enforcement that had led to this moment. The hearing on Sarah's emergency motion took place on a cold February morning in 2021, and it would become the kind of courtroom drama that defense attorneys dream about. Judge Maria Santos, a no-nonsense jurist with 15 years of experience in property law, was clearly unimpressed with the board's case from the moment Robert Chen stood up to represent the HOA. Patricia methodically presented the evidence, the email proving malicious intent, the documentation showing violations of proper procedures, the evidence of selective enforcement, and the financial records proving misuse of community funds. But the moment that sealed the board's fate came when Patricia played a recording of Sarah's original phone call with Margaret, a recording Sarah had legally made under her state's one-party consent law. In that recording, Margaret's voice was clear as she told Sarah, "We address violations as they come to our attention, but some residents require more attention than others. The board has wide discretion in enforcement, and residents who cooperate tend to have fewer problems." Judge Santos interrupted the proceedings at that point, asking Robert Chen directly whether the board maintained written policies for violation enforcement and how they determined which violations to pursue. Robert's stammering response made it clear that the board operated on personal whim rather than established procedures. But the judge wasn't finished. She demanded to see the board meeting minutes where the foreclosure action had been authorized. Robert was forced to admit that no such meeting had occurred. The three defendants had made the decision unilaterally, without input from the other board members or community notification as required by state law. Judge Santos's ruling was delivered with barely contained anger. She not only granted Sarah's emergency motion to stop the foreclosure, but issued a temporary restraining order, preventing the board from taking any enforcement actions against any residents until a full hearing could be held on the broader issues raised in the case. Her comments from the bench became local legend. "This court has rarely seen such a clear case of abuse of authority and disregard for basic due process rights. The defendants appear to believe that being elected to an HOA board grants them unlimited power to harass and intimidate their neighbors. They are mistaken. The temporary restraining order effectively paralyzed the board's ability to function, but the real consequences were just beginning. News of the dramatic court hearing spread quickly through Willowbrook Estates and beyond. Local television stations picked up the story, framing it as a classic David versus Goliath battle between a bullying HOA and a homeowner who fought back. The image of Sarah's innocent garden gnomes became a symbol of resistance against HOA overreach. But the media coverage had an unexpected consequence that would prove devastating for Margaret, Robert, and Linda. Other communities where they had previously lived began coming forward with stories of similar patterns of harassment and abuse of power. It turned out that Margaret Henley had been forced to resign from a previous HOA board after accusations of financial impropriety. Robert Chen had been sanctioned by the State Bar Association for using his legal credentials to intimidate non-lawyer opponents in civil disputes. Linda Vasquez had actually been arrested in another community for trespassing while conducting her violation patrols. These revelations transformed the case from a simple HOA dispute into a story about serial abusers of community authority who had been moving from neighborhood to neighborhood, leaving trails of harassment and intimidation in their wake. The full hearing on Sarah's lawsuit took place in March 2021, and by that time, the case had attracted attention from homeowner advocacy groups across the state. The courtroom was packed with residents from multiple communities who had experienced similar harassment. Patricia Wong's presentation was masterful. She demonstrated that the defendants had violated not just their community's governing documents, but multiple state laws governing fiduciary duty, harassment, and abuse of authority. The evidence showed that they had spent community funds on personal vendettas, violated residents' privacy rights, and created an atmosphere of fear and intimidation that had actually decreased property values in the community. But the most powerful testimony came from Sarah herself. In a clear, calm voice, she described the psychological impact of months of constant harassment, the fear of losing her home over garden gnomes, and the realization that she was living in a community where 3 individuals had appointed themselves as judge, jury, and executioner over their neighbors' lives. The defense put forward by Robert Chen was pathetic. He attempted to argue that the board had broad discretionary authority to enforce community standards, but he could not explain why Sarah's garden gnomes required immediate action while actual covenant violations by other residents were ignored for years. Judge Santos's final ruling exceeded even Patricia's expectations. She awarded Sarah full damages of $15,000 for legal fees, and emotional distress invalidated every fine and violation the board had imposed, not just on Sarah but on all the other affected residents, and ordered a complete audit of the HOA's finances and procedures. But the personal consequences for Margaret, Robert, and Linda were even more severe. The judge found that they had acted willfully and maliciously in their harassment of residents and ordered them to personally pay additional damages of $5,000 each. More importantly, she issued a permanent injunction preventing all 3 from serving on any HOA board in the state for 5 years. The financial audit ordered by the court revealed the full scope of the board's misconduct. They had spent over $18,000 of community funds on legal consultations and enforcement actions that primarily targeted their personal enemies rather than legitimate community concerns. They had also failed to properly bid maintenance contracts, instead awarding work to companies owned by their friends and family members at inflated prices. The revelation of financial misconduct triggered a state investigation that resulted in criminal charges against all 3 defendants for misappropriation of community funds. Margaret and Robert ultimately pled guilty to reduced charges and were ordered to pay full restitution to the community. Linda chose to fight the charges and was convicted at trial, resulting in probation and a substantial fine. But the story doesn't end there, because Sarah's victory had consequences that reached far beyond Willowbrook Estates. The case became a precedent cited by homeowner advocacy groups across the state. Patricia Wong used the legal strategies developed in Sarah's case to help dozens of other homeowners facing similar harassment from their HOAs. The state legislature even passed new laws strengthening due process protections for HOA residents and limiting the ability of boards to impose fines without proper procedures. Sarah herself became an accidental activist, speaking at homeowner association conferences and helping other residents understand their rights. She learned that knowledge truly is power, especially when facing bullies who count on their victims being too intimidated or uninformed to fight back. The Willowbrook Estates community underwent a complete transformation. The remaining board members, who had been kept in the dark about the harassment campaign, implemented new policies requiring transparency in all enforcement actions, formal procedures for violations, and regular community input on board decisions. Property values, which had actually declined during the period of board harassment and community conflict, rebounded stronger than ever. And yes, Sarah's garden gnomes returned to their rightful place among her flowers, where they remain to this day, symbols of a homeowner who refused to be intimidated and a community that learned the difference between reasonable governance and abuse of power. The lessons from Sarah's story are crucial for every homeowner living under HOA rules. First, know your governing documents, not just the rules, but the procedures that must be followed to enforce those rules. Second, document everything, every violation notice, every communication, every interaction with board members. Third, understand that compliance alone won't protect you from bad actors who use selective enforcement as a weapon of harassment. Most importantly, remember that HOA boards derive their power from the community they serve. They are not kings or dictators with unlimited authority. They are neighbors who have been entrusted with specific responsibilities and granted limited powers that must be exercised fairly and according to established procedures. Margaret, Robert, and Linda forgot that fundamental truth, and their abuse of power ultimately destroyed their ability to serve their community and cost them thousands of dollars in legal fees and damages. They learned the hard way that even the most intimidating bullies can be defeated when their victims understand their rights and have the courage to fight back. Sarah's garden gnomes might seem like a trivial thing to go to war over, but they represented something much more important. The right to enjoy your own property without fear of harassment, the right to fair treatment under established rules, and the right to hold community leaders accountable when they abuse their authority. In the end, Sarah didn't just win her case. She won back her community and helped establish protections that will benefit homeowners for years to come. Her story proves that sometimes the most powerful weapon against institutional bullying is simply refusing to be bullied and having the knowledge and courage to fight back. The next time you see a garden gnome, remember Sarah Mitchell's story. Remember that your rights as a homeowner are worth defending. That knowledge is your best protection against abuse of power, and that even the most intimidating opponents can be defeated when you understand the law and refuse to back down from what's right. What would you have done in Sarah's situation? Would you have removed the gnomes and hoped the harassment would stop? Or would you have stood your ground from the beginning? Share your thoughts in the comments below, because every homeowner needs to think about how they would respond if their own community leaders decided to target them for selective enforcement and harassment.